Please hold while the person you are calling is entering information to pay for this call. This call is not private. It will be recorded and may be monitored. If you believe this should be a private call, please hang up and follow facility instructions to register this number as a private number. To consent to this recorded call, press 1. To disconnect, press. Thank you for using Securus. You may start the conversation now.
Ms. Dunn, can you pause it?
I will. I need to make.
All right, so on mine, I'm at 100. Does anyone know anything else I can do to my computer speakers are at 100?
Probably close to this.
All right. Could she play on hers versus mine?
Yeah. I can.
Then I would have to.
And maybe put it.
Right now.
They can't hear anything, and I can't hear it as well either.
All right. Please be seated.
And so is this a recording that the parties have shared with each other and they both have the recording, or?
Yes, Your Honor.
Is that correct, Mr. Brown?
Yes.
How did you want to handle it? I know I need to be able to hear it, but this process, I'm unable to hear it now. All right.
We'll go back to the first way that we were doing it. Okay.
All right.
Number 25 and 26, People versus James Johnson, 25-1 FH, 2203 FH.
Jessica Blanche, appearing on behalf of People.
I do on behalf of James John. Sorry about that.
And Sam Bernstein as well, Your Honor, for the probation violation matter.
Okay. So looks like we have both a pretrial and a probation violation hearing. I assume they're going to continue to track together, but I don't want to make any gross assumptions. So what are we doing today, counsel?
In the pretrial, we'll be asking for an adjournment. I have been talking with Ms. Blanche, and I did not get a chance to meet with Ms. Johnson. We've been talking for the last day, so I'll be asking for an adjournment to further talk with Mr. Johnson about what we have discussed.
Okay. What about you, Mr. Bernstein?
Your Honor, I would like my case to track along, though I would like to say a few words about bond. If the court has a moment.
Sure. Give me 1 second here.
Your Honor, can I ask a quick question too? Did you get my letter?
Did I get your letter? I don't know that I did.
I wrote you a couple weeks ago.
I mean, I get letters all the time and I don't know, I don't remember it. So you might need to resend a copy or rewrite me. I'm not sure. So anyway, so let me ask this though, Ms. White, are we just adjourning the pretrial, or should we give you a final pretrial and a jury trial date? Or do you think that another adjournment of the pretrial might bring us to resolution? What are your thoughts?
I think another adjournment of the pretrial will let us know whether or not we will be going to jury or have a resolution.
Okay. So how far out would you like to adjourn this?
Just 2 weeks.
So that would be September
21st
at 1:30 p.m.
That's my son's birthday.
Okay. Mr. Bernstein, you want to talk about bond. So we're going to adjourn the violation of probation hearing to the same day. Okay, go ahead.
Thank you, Your Honor, for the opportunity to address bond. Mr. Johnson, we've had quite a few hearings in this case, Your Honor, and the probation violations have sort of trickled in, but a large part of those probation violations were new cases that had arisen while on probation. And ultimately, it was one case that he got that led to directly to the revocation of bond and remand to jail. That one case has been dismissed, and he had another case, which was 3 counts of resisting arrest that was dismissed yesterday. And those 2 cases really made up the bulk of what the probation violations were. And so when we kind of take those cases out of the equation, he's left with the original probation violations, which were certainly not as serious as those cases. I think they started out as collections matters, and then just certain behavior allegations that didn't rise to the level of crimes or were not charged as crimes. He has this case with Miss White that it sounds like they're going to be able to work it out, or at least it sounded hopeful that they'd work it out. And that's really the only other kind of big thing on his plate. And then there's like one other misdemeanor case that I have that I think will be concluded next week as well. So I'm asking the court if we take out of the equation of the bond determination, the cases that led to his remand now, and which are otherwise a large part of the probation violations, if the court could reconsider bond determination without those, we would appreciate that, Your Honor. I know Mr. Johnson has done a pretty good job of showing up to court when asked, and he's now in a place where he's very motivated to finally just resolve all these cases and be done with it and move forward, Your Honor.
Okay, I'll bite. Ms. Blanche, your response?
Well, Judge, one of the cases that unfortunately got dismissed, the officers couldn't make it to the exam. It was an R&O charge. He threatened one of our prosecutors during jail calls, and that is one of the main reasons I'm asking for you to keep him in custody. That is being reauthorized. But so not only is he on probation, he has new charges. And then he's threatening our APAs on jail calls. So I definitely think he's a threat to the community, and I'd like you to keep him remanded.
What are the allegations in that threat?
I'm gonna have to pull up the actual
allegations.
file.
Mr. Johnson?
Okay. If I mean, at the end of it, can I speak after everything is going through, Your Honor, if you would like?
Well, yes. The short answer is, Mr. Johnson, of course you can. But you need to know that anything you say, you're on the record, it can be used against you. So you want to be careful about your lawyer's advice to you. So,
yes,
I mean,
I definitely
let me just ask Mr. Bernstein, while Ms. Blanche is looking that up, you were sort of categorizing the violations and that most of them have gone away. The one you were referring to, I think, was probably the 5th one, that in the April where he sent the message to. Is that correct?
That was one of the allegations that I don't think ever led to a criminal charge.
If I can.
James, I'm sure the judge will let you speak, but we can't. I think you have to wait until Ms. Blanche has said her piece and that the judge is done asking his questions.
Okay.
Judge, he said during the jail calls, he said he'd clap Caitlin Kirby when he gets out.
Okay. So, all right. So, I don't know, Mr. Bernstein, Ms. White, do you want to talk to your client before he talks to me, or do you want to let it rip? I don't know.
No, I'm happy to talk to him, Your Honor, but if I could just address the jail call, because I've had the pleasure and opportunity of listening to 68 jail calls for Mr. Johnson. And I can say that those jail calls are something that, not Ms. Blanche specifically, but the prosecution is using against James in terms of trying to prosecute him for things. But it's not really working. There's like 68 incredibly boring and benign phone calls. And when he says clap her, he's talking about a lawsuit for malicious prosecution. And so there's a context to all these jail calls that are often being left out of like prosecutions against James. For example, they had a preliminary exam against James yesterday based on these phone calls for like witness intimidation. They ran the preliminary examination and then the case was dismissed at the conclusion of it. So, you know, I get that James is someone that, the office is trying to prosecute, but I think there's a context to these phone calls that he's talking about, suing for malicious prosecution and frustration with the prosecutor's office. He's not talking about literally killing people. It's within that context. Like the sentence he says, I have them transcribed. I can't find it right now, but it's something about clapping like a lawsuit or something. It's not like, I don't know what clap means exactly, but James, hold on. He'll let you talk, but I think maybe us and Sandra should talk too. But I dispute the categorization that it was like a threat towards a prosecutor. I do dispute that.
Well, he does say they should allow you to have boxing matches with motherfucking prosecutors. You should be able to fight the prosecutor, like literally fight them, knock them down. I can't wait until this lawyer get a hold of her ass for maliciously prosecuting me. You little white bitch. You listen, you little bitch. You listen to me right now. Ain't you little bitch? Suck my dick. That's what you do since you want to listen to my call so much. So there was follow-up after that, Judge, that was extremely threatening in this case.
All right. If Mr. Johnson wishes to speak, he may do so, but you need to know it's on the record, and go ahead.
Yeah. Yes, sir. I definitely understand that everything will be used against me. As Mr. Bernstein stated, and as well as Mrs. Blanche, they tried to pursue the charges or a charge for threatening a government official due to the statement of me using the exact words was that I was going to clap this, I was going to clap the motherfucking, excuse my language. I said, I'm gonna clap this motherfucking prosecutor on this malicious prosecution lawsuit in regards to them maliciously prosecuting me for malicious destruction of a building, which my child mother did not want to proceed with the charges. Like Sam Bernstein also said, they came with the witness intimidation on my child mother. My child mother came to court yesterday, and that case was dismissed. I mean, honestly, I've been in here since July 16th. You caused my bond, well, not you, but my bond was revoked due to a serious allegation of armed robbery, which was dismissed as well. And I also said in that report that from the beginning, I told them that the charges was fake, and I provided text messages. I provided the information to show that those allegations was fake. Ultimately, that case was dismissed as well in my preliminary exam. I've been incarcerated, like I said, since July 16th. I missed my 4-year-old son first day of school. I missed his birthday on August 13th. My son's birthday is our next court appearance, which is September 21st. Like I'm no fool nor no dummy to try to get out and cause any type of harm towards any type of law enforcement, any type of prosecutor, any type of judge, or any of that. At one point in time, yes, I was on the phone and I was stating some derogatory things, saying some profanity, using some profanity, but I was just simply angry because my child mother requested for me to get out of jail. I take care of my children. She was requesting for me to get out of jail, and yet and still they tried to proceed with these charges without using her and trying to tell her that it doesn't matter, about the case and stuff like that. Yes, I was angry. Yes, I used some profound language. Yes, I said some things, but I never made a threat towards any prosecutor. Never did I have the intention to make no threats towards no prosecution. The detective came and hollered at me about that as regards to what's going on with the threatening of the government official. Detective came and hollered and talked to me, and that was over a month ago or so. And I asked him at the end of that, I asked him, I told him, explain what was going on. I told him he could listen to the calls and listen to the complete sentences instead of the breakup of the phone call. If he listened to the complete sentences, I was simply talking about malicious prosecution lawsuit. I stated that. He told me at the end, once he walked me back down to the jail, that more than likely it wasn't going to be no charges pressed against me because he felt as if there's nothing, and that was Detective Ramsey, I think his name was. Beyond, like I said, I just want to get out.
I understand that you do, Mr. Johnson, but let me offer you this. I also have had litigants say things about me. And I don't care if they say that I'm not handsome or I'm not good or whatever. But I've also had people say things that I think are threatening. That, that people have said that, I mean, even if it's context or not, sir. And so when Ms. Blanche sort of quotes what you said and you responded saying it was vulgar, it might not have been appropriate, or you were angry, it's also the other side of that is that prosecutor who was on the phone with you was doing their job. I mean, and again, you may differ on that, and the process will determine whether you're not guilty or guilty, and there's not going to be a charge or whatever the detective said. But you knew you were being recorded and you were angry, and you still said things that I think could be taken as threatening. So I got to tell you that it concerns me that in anger you would say that in jail, knowing you were being recorded. So I have to tell you that here's the deal. I'm not going to let you out on a bond modification today. You're coming back in 2 weeks and it's your son's birthday, and maybe I'll change my mind, but I'll tell you what I won't do unless either Mr. Bernstein or Ms. White makes a very particular ask as to how you would be released, under what kind of tether or restrictions you would be released, and really very specifically how to do that in a way that I can be assured, number one, that you're not going to be a danger to anybody out in the community, and number two, that you're not a flight risk. And I'm not saying they didn't do their job today, because actually kind of I was thinking I was going to release you until I heard what you said. And so I just need you to understand that even when you're angry, sometimes what you say matters. And it may be that you didn't intend it as a threat, but somebody can hear that as a threat and feel threatened. And so that's not cool. That's not fair. And so I'm not saying I won't modify your bond in 2 weeks. I know it's your son's birthday, but I'm also not telling you or promising you that I will. But if we come back in 2 weeks and there's progress on the case that's pending, and or Mr. Bernstein or Ms. White makes a very particular or very specific ask about restrictions and tether and whatever that's going to look like, I'm not saying I won't consider it. Okay?
Okay. Thank you.
All right. So we'll see you back here on the 21st at 1:30.
All right. Thank you. Hey, Ms. White, you said you'll come talk to me about the possible resolution you got?
Yes.
Okay. Thank you.
Thank you, Your Honor.
Could you state your name, Mr. Johnson? We need the microphone on for Mr. Johnson, please. Thank you.
Johnson.
Hi, how you doing today?
I mean, I'm making the best of my situation.
Okay, let's verify your, you know the drill, contact information, and then we'll talk about bond to State of Michigan versus James Johnson. 22F11344. I have received a petition requesting a court-appointed lawyer. I will sign that. You may proceed when you're ready, Ms. Reed.
Thank you. Sylvana Reed, Assistant Public Defender, with and on behalf of Mr. Johnson. We have reviewed that complaint, so we will waive a formal reading and stand mute.
Okay, go ahead, Ms. Blanche.
Jessica Blanche, on behalf of the people. Judge, we're asking for $50,000 surety bond in this case. These stem from allegations where he's intimidating and making threatening, on the phone calls, he's making threatening statements regarding one of our prosecutors in our office. He is on probation currently with Judge Conlin for heroin and gun charges. He also has a violation of that probation up in front of Judge Conlin for 3 new delivery manufacturing heroin charges. He had a slew of other cases down in district court that the intimidation charges or these charges stem from, where the APA was listening to his jail calls. So I'm asking for a $50,000 surety bond given the nature of this case.
Okay, so let's okay, got that. I understand what we're talking about today, but the last time I saw Mr. Johnson, he was being held without bond on something. I think those were misdemeanor DV cases maybe that have been dismissed.
No, it was
Okay, hang on, Mr. Johnson. I know you want to talk to me and I will let you, like I always do. Just wait a second though, okay? What is still open, and is he in custody on any of these things?
Yes, Your Honor. He has a violation of probation up in front of Judge Conlin. He also has 3 charges pending in front of Judge Conlin for delivery manufacturing heroin in front of Judge Conlon.
Okay, 3 charges that have been bound over.
Correct. Those are, yes, those are in front of Judge Conlon.
But those are not, I'm sorry, I know I'm talking over you. I apologize, but I'm trying to get a handle on this. So he has probation on a case from 2020. He has the circuit court cases for the drug charges that are bound over, and those are pending trial.
Correct.
Okay. And what are the bonds on those things that he has?
He's currently remanded based on Wednesday. There was a bond motion argument, and this new case with our APA, I argued to keep him in custody, which Judge Conlon did. So he was remanded on those charges.
No bond on those 4 circuit court matters.
Well, there are 2 cases. There's multiple charges, but 2 cases, Judge.
1 on probation and 1 pending trial. All right.
Correct.
Okay. And that's it, right? He doesn't have anything else open because the misdemeanors were dismissed.
Correct.
Okay. He has a trespass for an arraignment with me on.
And I believe there's 3 counts of RNO that he's that we reinstated just recently. So he's probably gonna get rearraigned on those 2. But other than that, no.
Those are open at this time. Okay. All right.
Correct.
Okay. Mr. Johnson, this is where we are. You know, I'm always straight with you. Okay. So here's where we are. You can't get out of jail right now anyway. That's number 1. Number 2, you're accused of making phone calls that threatened a prosecutor. That's a very serious charge, as you know. Number 3, there's a statute in Michigan compiled law 765.6A that you and I've talked about this before. It requires a financial bond when a person has 2 or more felony convictions within the previous 5 years. That applies to you. So for all of those reasons, I'm going to be setting a financial bond for you. Okay. The prosecutor is requesting $50,000. I'm not certain that that's the amount that I will set. I'm talking right now. I haven't thought about what the amount should be, but it is appropriate for there to be a financial bond. It's appropriate for it to be high enough to complement you being in custody because of what you're charged with, the threats that are involved here. All right. So that's where I am right now. And I've told you the reasons why. You are welcome to speak to me very briefly if there's something that you want me to know, but we're not going to talk about the case. As always, you should not be talking about what you did or did not do, what you said or didn't say. We're not doing that. So if you start to talk to me like that, I will cut you off as always. Okay. So you know the drill and you know how it works. And you know that I'm willing to let you talk for a minute if you've got something to say that you think I need to know. If you don't have anything to say, that's fine too. I don't need to hear from you. And truthfully, most people in jail don't talk to me, but I know you like to talk. So you're welcome to go ahead if you'd like to briefly.
Yeah, as Ms. Blunt said, I do got those pending charges. And we did speak about it on Wednesday, as she said before. Okay. I understand both of you, your duties and her duties as, you know, your job pertains, but Colin, he gave me a little hope with possibly with the tether.
Okay.
On 21st, that's my son's birthday. He gave me a little hope. He told my attorneys to come up with some type of resolution or something with how regards to the tether. I don't know how the tether thing worked, but you know, he gave me some type of hope with the possibility of tether on the 21st.
Okay.
If I can do the same thing, I would appreciate it. But I also, like you said, you don't want me to go into the charges. So I can't really too much speak on that. But
right.
Like, I ain't the person that they trying to make me out to be, or the paperwork seems to be. I mean, obviously, you know, I understand that the charges from the looks of it is very serious, and I understand your duties as the prosecutor as well as the judge. But you know, I've been in jail since July. I mean, $50,000. I got that on 2 misdemeanors from Miss Kirby as well. This
Those
is like,
were dismissed though, right? Didn't have to post that.
well, one of the felonies that she brought upon me, which was a threatening a witness, intimidation or something stemming from the misdemeanor misdemeanor destruction of a property.
Right.
That case has been dismissed, but I still have the malicious or whatever, not the prosecution.
It's just destruction of property. That's still open?
Yes, I still got that open.
Okay.
I'm going to see Simpson on next week for that. So hopefully I'm trying to get out on that as well. Like I said, I've been a lot of stuff in here. My 2 4-year-olds started school this year. I missed one of my 4-year-olds' birthday. My son's birthday this coming up on the 21st. Like, I ain't the person that they saying I am, and I understand that the charges will look like as if I'm like some type of bad guy or some type of monster or any of that.
They do look like that. You're right.
That's not me. You know what I'm saying? Yeah, I made some mistakes. Wish I could correct them. I'm correcting them now. You know what I mean? I honestly, at the end of the day, you know what I'm saying? You got a job and you got your duties to the court as well, as far as the community, the safety and all that as well. But like, I ain't that guy, man, for real.
Okay.
For real.
All right. Thank you. Okay. Somebody who knows, tell me what the next court dates are. He's saying he's seen Judge Simpson on the MDOP on Wednesday, the 21st.
No, I see Colin on the 21st. I see Simpson on the 13th and the 14th.
That is correct.
November of September.
Yes.
Yes.
Next week. Okay. All right. And then you see Judge Conlin on September 21st.
On the 21st, which
And then we would be scheduling this on September 22nd.
That's which I'm hoping to get the tether.
Yeah. So your hope is that by the time you see Judge Simpson on this case, you will have a bond that you can post from me, or you will have an opportunity to have a tether or something like that.
And Ms. Blanche, I know this is off subject, but I wrote you a letter as well. Did you receive that?
So you can't write me a letter and you can't write the judge a letter. So even if you sent it to me, they wouldn't give it to me because you have an attorney and you have a Fifth Amendment right. So I can't speak to you through letters. So I wouldn't get it either. They would stop it in the mail.
It's not proper for an attorney that is representing the state to have direct communications with the defendant, even if the defendant has requested that communication, if the defendant is represented by an attorney. So it's not that Ms. Blanche is being difficult in that situation. It is unethical. And under the rules that govern the way lawyers behave, that is an ethical violation, and she could be reprimanded severely for that. So what she's saying is it's the policy of her office to not even give those letters to the prosecutors. So she did not receive a letter from you.
Oh, okay. I didn't know.
If there's something you need, you wouldn't know that. It's not something that you're expected to know. So if there's something that you want to communicate to the prosecutors, you have to do that by talking to your lawyer first. And then your lawyer can speak to the prosecutor. And just so you know, the reason behind that, Mr. Johnson, is so that prosecutors aren't accused of or able to manipulate defendants by having secret conversations with them. Okay, so it's for the defendant's protection.
Okay.
Is why the rule is there. Okay, so this is where we are then. The question is whether we're setting a bond that is high enough to keep Mr. Johnson in custody if everything else shakes out in a way that he can leave. And I guess that the way that I view that is that if all the other judges involved, Judge Simpson and Judge Conlin, are inclined to permit him to leave jail, then that decision should apply to this case also, because everybody knows what all of Mr. Johnson's cases are. And both Judge Simpson and Judge Conlin have regular dealings with Mr. Johnson and know who he is and what his background is and all of those things. So
I'm not a person though, man, honestly, man. Like,
yes,
I ain't no fool to do no shit or
Okay.
nothing.
That's not what I'm talking about right now. So I am going to set the $50,000 bond, but I'm going to permit a 10% on that. And I'm going to order a GPS tether with the hotspot, the prosecutor's office. Is that what you think, Ms. Blanche? I don't know if there's a tether request or.
There would be, but obviously I don't want to disclose the APA's where she lives. But obviously the prosecutor's office.
Do we want it to keep him at his home then?
I would appreciate that.
Ms. Blanche, I'm not trying, honestly.
Okay, Mr. Johnson, I know that I know what you're trying to say about this. I'm still setting the bond this way, okay? So I'll order a GPS tether. It might not matter because you might not be able to get out before you see Judge Simpson on the 22nd, but I'll order a GPS tether with home confinement to that Lori address.
Okay. Now,
and a 50,000 10%.
so I would have to pay the 50,000 10% and then get the GPS tether?
Correct. Assuming everything else gets resolved.
That's a lot. Honestly, I'm not gonna even be able to pay that.
Okay, I know it's a lot. And what I'm saying is that if the judges that are involved in your other cases believe that it is safe for you to leave the jail, then this bond will also be resolved in that manner when you see Judge Simpson on the 22nd. Okay, so all I'm doing right now is holding a place until you can see Judge Simpson on the 22nd.
Okay, so if I see Judge Simpson, I'm confused. I'm confused, Ms. Fink. So I would have to pay. All right. So once I see Judge,
so let's assume that things go the way you want them to. And when you see Judge Simpson on the 13th and 14th, he lowers your bond to a PR or to something you can pay. And when you see Judge Conlin on the 21st, he also makes it so that you can leave. All right. If all that gets resolved in the way that you would like it, then after you see Judge Conlin on September 21st, you're going to have this bond. It will be the only thing that's left, assuming those things go the way you want them to.
And Judge, this case is going to Conlin eventually.
Yeah.
So he's going to have all the cases. So he's going to make it the ultimate bond determination as it is.
Exactly.
On all of them.
Right. So if things go the way you want and you're going to be able to leave the jail after you see Judge Conlin on September 21st, you're still going to have to pay this bond that I've set. All right.
5,000.
Yes. And then get the tether put on. Okay. And then you'll see Judge Simpson on the 22nd, whether you've posted that bond or not. And then at that time, if you're still in custody, there can be your bond can be readdressed at that time. If you're out, it can still be readdressed. Okay. So because all this other stuff is happening, what I'm doing is not truly that important. We're really just making a record here and explaining the basis for my decision and getting everything kind of all lined up for you.
I mean, I understand that, I'm gonna have to end up paying the bond, but I mean, 5,000 is like kind of a lot. I was probably gonna be.
I don't think it, I guess what I'm trying to say to you is I don't think that this bond ultimately matters because Judge Simpson and Judge Conlin are still going to have the ability to control your bonds, including this one.
Okay.
Because you're going to be in jail until the 21st and you're going to see Judge Simpson on the 22nd. So we're only talking about
I think
one
his
day.
concern is that the 21st is his child's birthday and
he's still, yeah, well, I understand that, but I'll also tell you this, Mr. Johnson, missing your child's birthday is a difficult thing to do, and your kid is going to be fine. All right. So that's not the best place to put your energy, is making that the most important thing. Your child will be okay, especially if we're talking about a very young child. They may not even know that happened.
We turning it.
Okay. I think we're all set.
All right, John.
Okay, I don't want you to go to the Washtenaw County Prosecutor's Office for any reason. Also, do not try to deliver any mail to Miss Kirby at any location, okay? All right, I think we're finished. Anybody have anything else on this matter?
No, Your Honor, thank you.
Okay, thank you, Mr. Johnson. You're all set with me.
Have a good day.
Thank you. 11:34, Lori.
Now, hey, Miss Fink.
Yes.
Now, if my address or anything was to change, how would I change it with the?
You would have to talk to the tether people, and you would have to get permission from a judge to have that tether be to a different location.
Okay, thank you.
Thank you. All right, friends. That's that.
Cheers to the weekend.
We will all be on Old Squishy Gardener because of Mr. Barros, so, and Mr. Johnson.
Yeah. Oh yeah, it's like a subscription at this point for some people.
Today was, I mean, he was.
Okay, wait, we're still on YouTube. Stop. This part will also be on Old Squishy Gardener.